Hey, stop right there. Who are you and what are you doing in this house?
I live here. This is my home.
Can I see some ID? I'm going to need you to step outside, right now.
On what grounds?
Don't make this difficult.
The candle on her nightstand was still burning. Judge Joan Shelton had been up since before the sun, the way she always was when she had a full docket waiting. Her reading glasses were on, her second cup of tea was half finished and going cold beside a stack of case files she had been annotating since 5 in the morning. Briefs, motions, victim impact statements she read slowly and carefully, the way she believed every person who had ever trusted the court with their pain deserved. She was not expecting company. She was not expecting what was about to walk through her front door, uninvited, without a warrant, without probable cause, and without even the most basic regard for the constitutional rights of the woman standing in her own living room. What happened inside that house over the next 26 minutes would detonate across the national news cycle within 48 hours. It would trigger a federal civil rights investigation, force an emergency session before the Senate Judiciary Committee, and produce body camera footage so damning that legal experts would spend weeks struggling to find the right words for what they were watching. It would end one law enforcement career completely, and it would result in a criminal sentence that courthouse veterans described as the most consequential handed down to a police officer in the state's history. 15 years in federal prison. For a Tuesday morning that Officer Nestor Madison had decided, based on nothing more than the color of her skin, required his intervention. Judge Joan Shelton was not a woman you stumbled into lightly. 51 years old, 13 years on the federal bench, the kind of judicial record that got cited in Supreme Court briefs and assigned in first-year constitutional law courses at universities she had never even visited. She had spent her entire adult life inside the legal system, not because it had always been fair to people who looked like her, but precisely because it hadn't. She understood its mechanisms better than almost anyone in the country. She had dedicated her life to making them work the way they were supposed to. She had purchased her home 7 years ago. She knew every neighbor on the block by name. She had shoveled the driveway of the elderly couple next door every winter for 6 years without being asked. And this was not a suspicious woman in an unfamiliar place. This was a woman in her home on a Tuesday morning doing her job. And when Officer Nestor Madison looked through that window and saw her, everything he assumed, everything he decided in that instant without a single fact to support it, set in motion a chain of consequences he could not have imagined. Every single moment of it on camera. Joan Shelton did not grow up expecting the law to protect her. She grew up in Shreveport, Louisiana, in a neighborhood where the law showed up mostly when something had already gone wrong, and even then, not always on the right side of things. Her grandmother had lived through Jim Crow, and her father had been stopped and questioned by police so many times during her childhood that he had developed a specific voice he used when he saw a patrol car in the rearview mirror. Calm, measured, hands visible. She had learned that voice by osmosis before she was 10 years old. But Joan Shelton had also grown up in a house full of books. Her mother, a public school librarian named Ruth Shelton, believed with absolute conviction that a child who could read anything could become anything. She made sure Joan tested that theory early and often. By the time Joan was 12, she was reading case transcripts her mother had checked out from the university library downtown. Not because anyone told her to. Because something in the structure of legal argument, the way a well-built case moved from premise to evidence to conclusion, felt to her like the closest thing to justice that human beings had managed to put on paper. She wanted to be inside that system. She wanted to be the one building those arguments. She earned a full academic scholarship to Spelman College, graduated first in her class, went to Columbia Law on a merit fellowship, and distinguished herself so completely that 2 federal judges requested her as a clerk before she had even sat her final exams. She clerked for the Honorable Margaret Wu on the Second Circuit for 2 years, an experience she would later describe as the most formative of her professional life. She spent 8 years as a federal prosecutor after that. But her conviction rate was among the highest in the district. She tried complex financial crimes, civil rights violations, public corruption cases. She was known for two things above all else: an almost inhuman command of evidentiary procedure and an absolute refusal to pursue a case she did not believe in completely. She was appointed to the federal bench at 42, confirmed unanimously. In 13 years as a federal judge, she had written opinions that reshaped how courts in 4 different circuits approached Fourth Amendment protections, the very constitutional guarantees that Officer Nestor Madison was about to shred in her living room. She had received the Federal Bar Association's Lifetime Achievement Award 2 years prior. She mentored young black women in the law every single week, without exception. She had never, not once, received a judicial conduct complaint. Her colleagues called her one of the finest legal minds currently sitting on the federal bench in the United States. Her neighbors called her the woman who always remembered their birthdays. Officer Nestor Madison was about to make the worst mistake of his life. Wednesday morning arrived the way it always did for Joan Shelton. Quietly. Her alarm went off at 5:15. She had slept 6 hours, one more than her usual 5, which she would later describe to her clerk as practically a vacation. She made her bed before she did anything else, smoothed the comforter flat, squared the pillows, a habit her mother had installed so deeply it was no longer a conscious act. It was just the first thing her body did when the day began. She was out the door by 5:40 for her walk. Not a run. She had given up running 3 years ago when her left knee finally registered its formal objection after decades of early mornings. She walked instead, briskly for 40 minutes through the neighborhood she had chosen deliberately and carefully 7 years ago. Not because it was prestigious, because it was quiet, because the streets were wide and tree-lined, and the neighbors kept their yards and looked out for one another, and nobody bothered anybody. Because after the noise and weight of the federal courthouse, she needed somewhere that felt like stillness. She knew this neighborhood the way you only know a place after years of unhurried attention. She knew which oak tree on Pembroke Lane had the split trunk that bloomed white flowers every April. And she knew that the retired school teacher on the corner, a 71-year-old woman named Gloria Marsh, put her garbage out a day early every single week without fail. She knew the loose flagstone on the path outside number 44 that she had been meaning to report to the city for 2 years. She was back home by 6:25. She made tea, loose leaf, steeped exactly 4 minutes, a ritual she had maintained since law school. She fed her cat, a 12-year-old tabby named Thurgood Marshall, who accepted the food without acknowledgement, the way he accepted most things. She showered. She dressed carefully, the way she always did before a full docket day. Dark blazer, pearl earrings her mother had given her the morning of her Senate confirmation hearing. She wore them on days that mattered. By 7, she was at her desk in the front room, case files open, yellow legal pad beside her, working through the morning's preparation with the focused, unhurried attention she brought to everything. 6 hearings scheduled. She had notes on each defendant that went well beyond what the sentencing guidelines required. She believed that was the job. Not just applying the law, understanding the human being standing in front of you when you did it. Her neighbor, Gerald Okafor, later told federal investigators he had seen her through the window as he left for work at 7:10. Sitting at her desk, working, completely still, a woman at home on a Wednesday morning. Nothing more, until a patrol car she had never seen before turned slowly onto her street. Officer Nestor Madison had been on the force for 11 years. He was not. By any conventional measure, a standout. His academy performance had been average. His annual reviews used words like adequate and consistent, the kind of language supervisors reach for when they have nothing genuinely positive to say, but nothing actionable enough to act on. He had never been decorated. He had never been promoted, despite 2 applications for advancement that had gone nowhere without explanation, a fact he had nursed privately as a grievance for years. What his personnel file did contain, tucked into the internal affairs section that his supervisors had repeatedly chosen not to escalate, was a pattern. 8 complaints over 11 years. Every single one filed by a black resident. A man stopped 6 times on the same street in a single month. A woman questioned outside her own place of employment while unlocking her own car. A teenager detained for 40 minutes for riding a bicycle in a neighborhood nester. Madison had apparently decided, without any legal authority to do so, the boy had no business being in. 8 complaints. 8 times the department had looked the other way. Madison was 41 years old. He had grown up in a small, predominantly white suburb 2 counties over, a place where, as he would later acknowledge under oath in a deposition that became one of the most quoted documents in the entire federal proceeding, he had been taught, not explicitly but consistently and effectively, that certain neighborhoods had a certain kind of resident, and that anything outside that template was worth a second look. He did not frame it as racism when he said it. And he framed it as instinct, as experience, as the kind of street-level judgment that, in his words, kept communities safe. The federal prosecutor would later spend 45 minutes in front of a jury dismantling that framing piece by piece with the precision of someone who had been waiting a long time for exactly this opportunity. That Wednesday morning, Madison was running a routine patrol through the Pembroke Hills district, an area he had been assigned to for 14 months. By his own account, he had driven past Judge Joan Shelton's home dozens of times. He had never stopped before. Nothing had ever, by any objective measure, given him cause to. What was different that Wednesday was not the street. It was not the house. It was not the time of morning or the weather or anything that changed in the external world between his previous patrols and this one. What was different was that this time he saw her clearly through the front window. A black woman, alone in a large house in a quiet, affluent neighborhood, moving comfortably through rooms that his mind, in the fraction of a second it took to form the thought, had already decided did not belong to her. He pulled the patrol car over. He called it in as a suspicious persons report. And with that single transmission, he ended his own career. He just didn't know it yet. Judge Joan Shelton heard the knock at 7:23. She noted the time instinctively, a habit so deeply embedded from years on the bench that she logged timestamps the way other people blinked. She set her pen down, but closed the file she had been working through, removed her reading glasses, and placed them on the legal pad beside her half-finished tea. She was not alarmed, not yet. She opened the front door to find Officer Nestor Madison standing on her porch in full uniform, one hand resting on his belt, his posture carrying the particular brand of manufactured authority she had seen performed in her courtroom hundreds of times. Behind him, his patrol car sat idling at the curb with its lights off. No emergency, no urgency. Just a man who had decided, on no legal basis whatsoever, that her Wednesday morning required his presence. He asked her who she was and what she was doing in the house. She looked at him for a moment without speaking. Not out of shock. Joan Shelton had not been shocked by this particular flavor of presumption since she was approximately 19 years old. She looked at him because she was already thinking, already assessing, already doing what she had spent 30 years training her mind to do in the opening seconds of any proceeding that mattered. She had a choice to make, and she made it quickly. She could tell him exactly who she was. She could retrieve her federal judicial credentials from the office down the hall, place them in his hands, and watch his face collapse in real time. It would have been over in 60 seconds. He would have retreated to his patrol car, and the incident would have ended there, unrecorded, unexamined, and unpunished. One more quiet injustice absorbed into the long, uncounted ledger of quiet injustices that black professionals in this country carry without ever being asked about them. She decided not to do that. Instead, Judge Joan Shelton, Chief Judge of the Federal District Court, 13-year veteran of the federal bench, one of the foremost authorities on Fourth Amendment jurisprudence, currently serving in the United States judiciary, told Officer Nestor Madison only what any citizen in any home in this country is ever required to tell a police officer who arrives without a warrant and without probable cause. Nothing. She asked him calmly what the nature of his concern was. She asked what specific suspicious activity had been reported and by whom. She asked on what legal basis he was requesting entry to a private residence. She kept her voice level and her expression neutral, and she watched him carefully, the way she watched witnesses on the stand when she already knew what they were about to reveal about themselves. She also did one other thing. She walked to the hallway table, picked up her phone, and pressed record. She had no idea her security system had been recording since the moment he stepped onto the porch. Officer Nestor Madison was already on camera. He just didn't know it yet. What happened over the next 19 minutes was not a misunderstanding. That would become one of the central arguments of the defense, that Officer Nestor Madison had acted in good faith on an ambiguous situation, that his decisions in the moment reflected training and instinct rather than malice, that reasonable officers in similar circumstances might have done the same thing. The federal prosecutor would dismantle that argument so thoroughly and so early in the trial that the defense never fully recovered from it. Because what the cameras recorded was not ambiguity, it was a sequence. A deliberate, escalating series of decisions, each one worse than the last, each one chosen freely by a man who had been told clearly and repeatedly that he had no legal standing to be where he was. It started at the threshold. When Judge Shelton declined to answer his questions beyond what the law required of her, Madison's demeanor shifted. The performative calm he had arrived with dropped away quickly. He told her that her reluctance to cooperate was itself suspicious. He told her that residents with nothing to hide didn't ask questions. But he used the word attitude twice in 40 seconds, a word she would later describe in her victim impact statement as one she had heard directed at black women in professional settings her entire life, deployed always to reframe composure as aggression and self-possession as threat. Then he stepped inside. Without invitation, without consent, without a warrant, without any legal authority recognized under the Fourth Amendment of the Constitution that Joan Shelton had spent 13 years on the federal bench defending. He simply crossed the threshold of her home and walked in. She stated clearly, calmly, and for the record that he had entered without her consent and without legal authority. She said it in the precise language of constitutional law because she knew, even in that moment, that every word she spoke was evidence. Then he told her to stop talking. He told her that she was obstructing his investigation. He told her there was no investigation. And then, in the same breath, contradicted himself by beginning to move through her front room, opening interior doors, glancing into spaces he had no right to enter. His hands went to her phone. When he realized she was recording, something shifted in him that the camera captured completely, and the defense would spend weeks trying to contextualize away. His voice dropped, his jaw tightened. He told her to put the phone down. She told him she had every legal right to record an officer in the performance of his duties in her own home. He grabbed it out of her hand. What he did not know, what neither his grabbing hand nor his rising voice nor his 19 minutes of constitutional violations had accounted for, was the camera mounted in the upper corner of her entryway, and the one above the kitchen doorway, and the one covering the front porch, all of them recording. All of them uploading automatically to a cloud server with a timestamp that would later be entered into federal evidence. Every second of it preserved. Perfectly, permanently. It was the word trespassing that made her decide. Madison had completed his illegal search of her front room, found nothing, because there was nothing to find, and was preparing to leave when he turned back to her one final time. He told her that the homeowner of this property would be contacted and informed about the situation. He told her that if he saw her in this neighborhood again, he would not be as patient. He used the word trespassing. He used another word after it that the camera recorded with complete clarity, and that, when played in a federal courtroom 7 months later, made 3 jurors visibly flinch and caused the court reporter to pause for the first time in her 22-year career. Joan Shelton did not react. She had been still for 19 minutes. She had absorbed every violation, every presumption, every word he had aimed at her with the practiced stillness of a woman who had learned, long before she ever put on judicial robes, that the most powerful thing she could do in a room where someone was trying to diminish her was to remain completely, unshakably composed. She had not raised her voice once. She had not answered a single question she was not legally required to answer. She had simply watched and listened and documented and waited. She walked down the hall to her home office. Madison, apparently uncertain whether she was retrieving a weapon or calling someone or simply leaving the conversation, stayed where he was. He would later be unable to explain, under cross-examination, why he did not follow her. The prosecutor suggested it was because some part of him, even then, had begun to understand that something was wrong with the picture he had been constructing since he pulled up to the curb that morning. He denied it. The jury did not believe him. Judge Joan Shelton returned to the front room 30 seconds later. She was carrying her federal judicial credentials, her official bench identification, her appointment documentation, her chief judge designation, in a leather folio she had owned since her first day on the federal bench 13 years ago. She placed it open on the coffee table directly in front of Officer Nestor Madison and took one step back. She said nothing. She let the credentials speak. The silence that followed lasted 11 seconds. The camera recorded all of it. Madison looked at the folio, looked at her, looked back at the folio. The color, witnesses would later describe, drained from his face in a way that was almost clinical to watch. Not a blush, not a flush, but a genuine, full departure of blood from the surface, as if his body had received information that his mind had not yet processed, and was responding ahead of it. He opened his mouth. Nothing came out. Joan Shelton, chief judge of the United States Federal District Court, looked at the man who had just spent 19 minutes violating her constitutional rights in her own home, and said, with the same measured calm she had maintained for every one of those 19 minutes, "I suggest you contact your supervisor, right now, before I do." He was out the door in 40 seconds. She picked up her phone and called the FBI. The FBI picked up on the second ring. That was the first signal to everyone who would later study the timeline of this case that what had just happened inside Joan Shelton's home was not going to be handled the way these things were usually handled. There would be no internal affairs form filed and forgotten, no quiet conversation between supervisors, no offer of a formal apology in exchange for discretionary silence, and no carefully worded departmental statement expressing regret for what it would inevitably describe as a miscommunication. Judge Joan Shelton had the direct line of the Bureau's Civil Rights Division chief saved in her phone. She had put cases in front of that office. She had ruled on warrants they had requested. She had, on 3 separate occasions, written opinions that expanded the legal tools available to federal investigators pursuing exactly the kind of civil rights violation that had just been committed against her in her own living room. She knew precisely who to call. She called them at 7:44 in the morning. By 9:15, 2 senior FBI agents and a federal civil rights prosecutor were sitting in her front room, watching security footage on a laptop she had already transferred it to, taking notes with the focused, unhurried attention of people who recognized immediately that what they were looking at was not a complicated case. It was a clear one. Special Agent Renee Caldwell, a 17-year veteran of the Bureau's Civil Rights Division, would later tell investigators that in nearly 2 decades of reviewing police misconduct cases, she had rarely seen evidence this unambiguous. Every violation visible, every word audible, every timestamp intact. A sitting federal judge in her own home subjected to an illegal search, an illegal seizure of her personal property, and a racial slur delivered on camera by a uniformed officer who had fabricated his entire legal justification for being there. But Agent Caldwell was experienced enough to know that what looked like an isolated incident almost never was, and she requested Madison's full personnel file before she left the house that morning. What she found inside it opened a second investigation before the first one was 24 hours old. 8 prior complaints. Every complainant black. Every complaint dismissed, reduced, or quietly archived without meaningful consequence by a chain of supervisors who had looked at the pattern in front of them and chosen, repeatedly and deliberately, to see nothing. A man stopped 6 times in a month on the same block. A woman detained outside her own workplace. A teenager held for 40 minutes for riding a bicycle. The Bureau didn't stop there. They subpoenaed 5 years of patrol records, stop and frisk data, and internal communications from Madison's entire precinct. What the data revealed didn't just implicate one officer. It implicated a system, as black residents in the districts Madison had patrolled were stopped and questioned at a rate 19 times higher than white residents in identical demographic situations. 19 times. The department's internal review board had looked at that data every year for 5 years. Not one person had asked a single question about it. The story broke nationally on Thursday morning. 41 hours after Officer Nestor Madison had walked uninvited into Joan Shelton's home, a 2-minute clip of the security footage, reviewed, authorized for release, and personally delivered to 3 major news networks by Judge Shelton's attorney, was playing on every major television screen in the country. Legal analysts were describing it as the most unambiguous recorded civil rights violation by a uniformed officer they had seen in years. Former federal prosecutors were being pulled into studios before breakfast to explain, in plain language, exactly how many laws had been broken in those 19 minutes and what the sentencing exposure looked like for each one. By Thursday afternoon, the department had suspended Madison without pay. By Thursday evening, Judge Shelton's attorney had established a dedicated intake line for anyone who had experienced similar treatment from officers in the same precinct. It rang for 72 hours without stopping. What came through that line over the following 2 weeks was not a handful of isolated grievances. It was a flood. 51 individuals, each with a story that followed the same recognizable architecture, the same presumption, the same language, the same suffocating logic of a system that had looked at black people living their ordinary lives and decided, over and over again, that ordinary required explanation. A cardiologist named Dr. Wendell Price had been stopped outside the hospital where he had worked for 16 years, handcuffed on the sidewalk while still in his scrubs, and detained for 38 minutes because Madison had decided his presence in the parking structure at 11 at night was suspicious. Dr. Price had just finished a 14-hour shift. He had filed a complaint the following week. It had been closed without investigation within 10 days. A woman named Sonia Treadwell, a 44-year-old high school principal, had been questioned for 25 minutes on her own front lawn while unloading groceries from her car because a neighbor, who was never identified in any official report, had allegedly called in a concern. No record of that call existed in the dispatch logs. It had never existed. A 62-year-old retired judge named Clarence Obie had been stopped while walking to his mailbox in a bathrobe on a Sunday morning and asked to produce identification on the grounds that he appeared, in Madison's words, out of place. Judge Obie had lived in that house for 23 years. Every single one of them had filed a complaint. Every single complaint had been dismissed, minimized, or made to disappear inside a process specifically designed to absorb them without consequence. Federal prosecutor Diana Reeves, and who had been assigned to lead the criminal case against Madison, would later say in a post-trial interview that reviewing those 51 files was the moment the case transformed in her mind from a prosecution into a reckoning. She had stopped counting the number of times the word suspicious appeared in Madison's reports. It appeared, across 11 years of documentation, 147 times. Every single time, the subject was black. The trial began on a Monday in October. The federal courthouse was full before the doors opened. Media vans had been parked on the surrounding block since the previous Friday. Civil rights organizations had flown representatives in from 14 states. Former colleagues of Judge Shelton's, sitting federal judges themselves, defilled 2 full rows of the public gallery in a display of institutional solidarity that courthouse staff described as unprecedented in the building's history. Nestor Madison arrived with 2 defense attorneys and the particular expression of a man who had spent months being told by people he was paying significant amounts of money that there was still a viable path through this. He sat down at the defense table, straightened his tie, and did not look at the gallery. He did not look at Joan Shelton either. She was seated in the front row beside her attorney, dressed in a charcoal blazer and the pearl earrings her mother had given her the morning of her Senate confirmation hearing. She had worn them deliberately. She looked straight ahead. Federal prosecutor Diana Reeves opened for the government in 11 minutes flat. But she did not use dramatic language. She did not editorialize or appeal to emotion or reach for rhetoric. She simply told the jury what the evidence would show, in the order it would show it, with the calm precision of someone who had reviewed that evidence so many times she could have recited it in her sleep. When she was finished, the courtroom was completely silent for a moment before the judge called on the defense. The defense opening lasted 40 minutes. It used the words misunderstanding 7 times and good faith 11 times. It argued that Madison had responded to what he genuinely believed was a legitimate concern, that nothing in his actions that morning reflected anything other than standard police procedure, and that the characterization of his conduct as racially motivated was a projection imposed on an ambiguous situation by a politically charged atmosphere. Then Diana Reeves played the footage, all 26 minutes of it, unedited, uninterrupted, on a screen large enough that every juror could see every expression on every face without straining. The courtroom watched in the kind of silence that isn't peaceful, the kind that accumulates, that gets heavier with each passing minute, that presses down on everyone in the room differently depending on what they already knew about the world before they walked in. They watched Madison cross the threshold without consent. They watched him move through rooms he had no legal right to enter. They watched him take the phone from Joan Shelton's hand. They heard the word he used when she asked for his badge number. They saw his face when she placed her credentials on the coffee table. They saw all 11 seconds of silence. When the footage ended, Juror 4, a 53-year-old retired schoolteacher named Barbara Okonkwo, who would later be elected foreperson, was seen by 3 separate observers wiping her eyes with the back of her hand. Madison's lead attorney requested a 10-minute recess. The judge denied it. The jury deliberated for 9 hours and 40 minutes across 2 days. It was not, by any account from those inside the deliberation room who later spoke to journalists, a contentious 9 hours and 40 minutes. It was a thorough one. Foreperson Barbara Okonkwo had insisted, from the moment the jury retired, that every charge be examined individually and completely before any vote was taken. She wanted each juror to be able to say, for every single count, exactly what evidence supported the verdict they were returning. She believed that was what the weight of the case required. On a Tuesday afternoon, 4 weeks after the trial began, the jury returned. Guilty on all 8 federal counts: civil rights violation under color of law, illegal search and seizure, criminal trespass, assault, deprivation of constitutional rights, obstruction, falsifying an official report, the fabricated suspicious person's call he had never had any legal basis to make. And the eighth count, added by the grand jury after reviewing the full scope of the departmental evidence, conspiracy to deprive civil rights, reflecting the years of institutional protection that had allowed his conduct to continue unchallenged. The courtroom did not erupt, it exhaled. Sentencing was scheduled 6 weeks later before federal judge Raymond Osei, a 20-year veteran of the bench who had reviewed every piece of evidence, every victim impact statement, and every prior complaint in Madison's 11-year record before he entered the courtroom that morning. He had also read, in full, the departmental data showing black residents stopped at a rate 19 times higher than white residents in Madison's patrol areas. He had read every one of the 51 victim accounts collected by the intake line. Joan Shelton delivered her victim impact statement standing at the podium with no notes. She spoke for 22 minutes. She did not speak about anger. She did not speak about vengeance or satisfaction or the personal relief of a verdict. She spoke about a pediatric nurse named Amara Collins who had stopped driving to night shifts alone after her third encounter with Madison's precinct because the fear had become too heavy to carry. She spoke about Dr. Wendell Price, who had taken a leave of absence from the hospital after his detention because he could not find a way to walk back into that parking structure. She spoke about a generation of black professionals in that city who had learned, through accumulated experience, to make themselves smaller in spaces they had every right to occupy fully. She looked directly at Nestor Madison when she said it. He looked at the table. Judge Osei sentenced Officer Nestor Madison to 15 years in federal prison without the possibility of parole. The civil lawsuit settled 31 days later. The city agreed to pay Joan Shelton $14 million, the largest individual police misconduct settlement in the state's history. An additional $39 million was distributed among the 51 additional victims over the following 14 months. The mayor resigned on a Wednesday. The police chief followed him out the door on Friday. Madison's wife filed for divorce before he reported to the federal facility where he would serve his sentence. His appeals were denied at every level. He entered the facility on a gray November morning and did not look back at the cameras assembled outside. He had 11 seconds of silence to think about for the next 15 years. The city did not get to decide what came next. Joan Shelton did. And that was the part of the settlement that the legal community talked about longest. Not the $14 million, significant as it was, but the structural demands that Judge Shelton's attorney had insisted on as non-negotiable conditions of resolution. She had not come to that negotiating table looking for a check. She had come looking for architecture, for the kind of lasting institutional change that would still be functioning and enforceable long after the news cycle had moved on and the cameras had gone home and the city's leadership had been replaced by people who had not been personally implicated in any of it. She got what she came for. The consent decree ran to 63 pages. It placed the entire police department under federal oversight for a mandatory 7-year period, met with quarterly reporting requirements reviewed by an independent monitor appointed by the Justice Department. Every policy, every procedure, every hire at the supervisory level required federal approval before it could be implemented. The Internal Affairs Division was dissolved entirely and rebuilt from the ground up under civilian leadership, with independent investigators who had no prior relationship with the department and no institutional incentive to protect it. Body cameras became mandatory for every officer on every shift without exception. Footage was to be stored on an independent server with no departmental access to the archive. Complaints filed by civilians would be investigated by the Civilian Oversight Board first, with departmental involvement permitted only after the independent review was complete. The Complaint Review Board itself was Joan Shelton's specific design. She had spent 3 weeks drafting its structure personally, in the evenings after her court day ended, at the same kitchen table where she had been sitting when Nestor Madison knocked on her door. The board had subpoena power. It had the authority to recommend criminal referrals. It published full public reports on every investigation it conducted, with findings written in plain language, specifically so that the residents most affected by policing in that city could read and understand them without a law degree. She agreed to chair it for the first 2 years herself. The training overhaul was total. Every officer in the department completed a 40-hour course on constitutional law, implicit bias, and de-escalation techniques developed in partnership with 3 civil rights organizations and 2 university law schools. The course was not optional. It was not a single afternoon seminar followed by a certificate and a forgotten binder. It was tested, tracked, and tied directly to advancement eligibility. The case entered law school curricula within 18 months of the verdict. It was taught not only in constitutional law courses, but in criminal procedure, evidence, and legal ethics classes at 61 law schools across the country. The security footage from Joan Shelton's front room became the centerpiece of a Justice Department training module on Fourth Amendment violations distributed to every federal law enforcement agency in the United States. At the FBI Academy in Quantico, where Judge Shelton was invited to speak 14 months after the verdict, she stood in front of 230 new agents and said something that several of them would later describe as the single most clarifying thing they heard during their entire training. She said, "The Constitution is not a document that protects people from the government in theory. It is a document that requires people inside the government to protect it in practice, every day, in every interaction, regardless of who is standing in front of you." She said, "I am standing here because I had the resources, the knowledge, the platform, and the cameras to fight back. Most people don't. Your job is to make sure they don't need all of that to be safe in their own homes." The room was silent when she finished. It was a different kind of silence than the one that had followed the security footage in the courtroom. That silence had been heavy with what people were processing. This one was clean. It was the silence of people deciding something. There is a photograph taken outside the federal courthouse on the day the verdict was read. Joan Shelton is standing on the top step, her attorney beside her, the November sky flat and gray behind them. She is not smiling. She is not raising a fist or embracing anyone or performing the kind of visible triumph that cameras tend to wait for outside courthouses on days like that one. She is simply standing there, looking directly into the lens, with the expression of a woman who has just watched something she always believed was true get confirmed in the most public and irrefutable way possible. She looks tired. She looks certain. She looks like someone who knew, from the moment she placed those credentials on the coffee table, exactly how this was going to end, and who had done every single thing required to make sure it did. That photograph ran on the front page of 11 national newspapers the following morning. Nestor Madison, at that same moment, was being processed into the federal facility where he would spend the next 15 years. His badge had been surrendered. His pension had been forfeited. His name had been entered into the National Law Enforcement Decertification Database, meaning he would never serve as a police officer in any jurisdiction in the United States for the remainder of his life. His appeals had been denied. His attorneys had exhausted every available argument. There was nothing left. And the department he had served for 11 years had been dismantled and rebuilt around the wreckage of what he had done. The city that had protected him through 8 dismissed complaints, through years of ignored data, through a culture of institutional loyalty that had consistently chosen the comfort of its officers over the safety of its residents, had paid $53 million in settlements and lost its mayor, its police chief, and 3 senior city council members who had overseen the Internal Affairs Division during the years the complaints had been buried. None of that happened because the system worked. It happened because Joan Shelton made it work. Because she had the knowledge to recognize every violation as it was occurring and the discipline to document it in real time. Because she had spent 30 years building exactly the kind of credibility and institutional access that a moment like this required. Because she had the cameras. Because she had the contacts. Because she made the call at 7:44 in the morning before Madison's patrol car had finished turning off her street. And because she made one decision standing at her front door in the gray early light of a Wednesday morning that changed everything. She decided not to tell him who she was. She decided to let him show her and the world exactly who he was instead. That decision cost Nestor Madison 15 years of his life, $14 million of his city's money, and every professional credential he had spent 11 years accumulating. It cost Joan Shelton a Wednesday morning she had planned to spend preparing for a sentencing hearing. She was back on the bench the following Monday. Some people, when they are shown exactly what they are made of under pressure, discover something they didn't know was there. Joan Shelton already knew. She had always known. She had been preparing for that moment in one way or another since she was a 12-year-old girl in Shreveport, reading case transcripts in a public library and deciding that the law was something worth fighting for. She fought for it in her courtroom every day for 13 years. On one Wednesday morning in her own living room, she fought for it one more time. And she won. If this case made you feel something, drop it in the comments. And if you think this was the most devastating accountability moment you have ever seen, wait until you see what happened in the case on your screen right now. Because that one is even harder to believe.